This Criminal Code Amendment Bill 2025 has passed its first reading, but it's not the punishments that have tongues wagging. It's the language. Words matter. And in this bill, some say they wound more than they protect.
Well, the bill proposes life imprisonment for defiling minors, a move hailed by many. But critics argue that the wording of key provisions is vague, archaic, and dangerously open to abuse. But the drafting raises real problems that could hurt women, girls, and even enforcement, as the section raises penalties for anyone who unlawfully supplies anything to procure the miscarriage of a woman. Critics argue that the wording of key provisions is vague as well. Anyway, joining us for this discussion are the Executive Director, DNF Survivor Support Center, Dorothy Njemanze joins us, and we also have a lawyer and civil rights activist, Dr Abiola Akiyode-Afolabi, who also joins us this morning for this conversation. Welcome, and thank you so much for joining us, ladies.
Yeah, good morning.
Thank you for having us.
Very interesting conversation that we're about to have. First of all, I'd like to get your reactions to when you heard the news. What was your take? I'll start with you, Miss Dorothy.
Okay, I would say my reaction straight up is that lives of human beings are not being taken as seriously as should yet again. The language, in fact, the language in itself is traumatizing. There seems to be a lot of focus again on the perpetrators, and then it gives me this sense of it's another effort to score political goals. You know, that's what it gives me. That's what it gives me. And why do I say so? I would think that if there's anything being done to any law, it should speak to the gaps that the previous one had. And I don't see anything much by way of provisions for the victims, you know, of whatever the situations are. I don't see any practical commitments that any government, ministry, department, or agency is supposed to have, you know. And so it just keeps everything vague and still leaves the burden of bearing the access to justice cost on survivors of sexual and gender-based violence, you know, as far as I'm concerned, on the victims. And so I think that's a very, very critical gap that I'm very worried about. And if that is not addressed, what is proposed will at best add to the increasing statistics of the rising statistics of femicide, you know, from what there is. You know, that's pretty much it. I'm very worried about it, and I'm very worried that it's, from what it looks like, from what it sounds like, and what it looks like, it's just going to end up costing more lives. That's more avoidable deaths.
Dr. Akiyode-Afolabi, do you share same worry?
Yes, I do. But however, I want to just start by saying that when I saw the headlines, particularly when it has to do with defilement and the fact that life imprisonment is being proposed, well, I thought that we were gradually getting there because, of course, defilement of children has been a major issue for people who are working in this area. I would say that there are several issues in the bill, just as Dorothy said, you know, that are of great concern. And so looking at the Criminal Act itself and see what it's following, this is an act that came to being in the early 1916, and so following the British colonial model. So one would think that if there is an attempt to amend that act in 2025, it should be able to come in concomitant with what we would expect to see as best practice in 2025. I must say that there are some areas that, from my own legal point of view, are areas which are a welcome shift, and I will give you an example. For example, decriminalizing attempted suicide. All of us know how the situation in the country is, the question of mental health and a whole lot of other things affecting people. So that's, for example, it's one area that I feel it's commendable in whatever they have done. But however, if you take a look at every other thing, particularly when it has to do with the issue of supplying drugs, instruments for abortion, it's very unclear. Just as she said, its language is archaic, it's not clear, and it's not a language that we would expect a good legislative drafting to have in 2025, amongst other things that are in the bill that one needs to speak about.
Okay, before we get into the next question, we want a very quick break. We'll come back and then we'll proceed to the next question. Please stay with us.
Welcome back. We're still looking at concerns over the draft of Criminal Code Amendment Bill 2025. We have two distinguished ladies joining us for this conversation. We have the Executive Director, DNF Survivors Support Center, Dorothy Njemanze, and lawyer, civil rights activist, Dr. Abiola Akiyode-Afolabi. Right before the break, we had talked about what your reactions were when you heard about this. But let me come back to you, Dorothy Njemanze. Let's look at the language of this bill, how it legally sounds. Do you think that this language being used in terms of it being vague, do you think it would have a lot of force when it comes to applying what definitely will be the result of anyone who carries out this act? Do you think it would actually hold water, rather, or you think it's just there?
Of course, I mean, something like miscarriage, abortion and miscarriage are one and the same thing. And the use of the word miscarriage, in the bill, miscarriages occur naturally with so many people, and they're triggered by a lot of factors for so many individuals. So one would wonder how anybody in 2025 with a lot of artificial intelligence amongst other things that are available would come and use the word miscarriage, mischievously as far as I'm concerned. Different things naturally trigger miscarriage occurrences. And so it sounds more to me like there has been some kind of an effort at stigmatizing miscarriage. So what it sounds in practical terms to me would be that women are advised to ensure that pregnancies go through term, at all costs. That's how it feels to me. And if it feels that way to me, imagine the numerous women, who need to bear pregnancies. Imagine the numerous children who are bearing pregnancies, amongst other things. What are the interpretations? How does these things act out in the grander scheme of things? And then on grounds of hypocrisy, a lot of people have put themselves up as enforcers of a lot of harmful normative practices to promote all these ideas. First of all, the misleading terminologies are going to further empower these people to further vilify and endanger the lives of women and girls at risk. I would have expected with the very high rates of child sexual predation, the lack of clarity. So Dr. Abiola earlier on had referenced being happy to see that now people are talking about life imprisonment. I mean, guided by the provisions of the Child Rights Act and even the Violence Against Persons Prohibition Act, I would want to believe that the basic minimum acceptable would be life imprisonment. I would want to believe that we would not give room for reducing the gravity of any of these basic things. But I foresee empowering, whether it is people practicing faith or cultural issues, or even basic morality police, there's basic morality police abusers, and that's how I see that. I foresee the present wordings of the amendments as empowering of these people to perpetrate more crime. It now takes away a lot from your bodily autonomy. You now seem to need to explain a lot of things that have led to natural traumatic experiences like miscarriages that you have suffered amongst other things. And I think it is not. I think it is not a right. I don't think it is a fair thing to do. And I think this is an opportunity to revisit the language, the traumatizing language, and the quite inappropriate language that has been put together in this one. That's very political drafting, and I align with Dr. Abiola on this.
Thank you very much, Mrs. Njemanze. My next question is for Dr. Akiyode-Afolabi. But before I ask my question, I want us to take a listen and watch this video.
I propose that it should be 20 years and underage. Because I've seen cases of boys and girls under 10 years old, 5 years old, defined by adults.
You have proposed that for minors, defilement should carry 20 years. Any seconder?
Yes, sir.
Yes. A more severe one? There's a motion. Yes.
Mr. Chairman, I second the motion, ably moved by Senator Adam Oshomole.
That for minors.
For minors. That the penalty should be 20 years instead of 10 years.
20 years.
20 years.
Imprisonment.
I so second.
And no option of fine.
No option of fine.
Well, so is Senator Aledo, you wanted to say something?
I wanted to propose a more stiffer punishment for defilement. Life imprisonment. Because in other climes, actually it's life imprisonment. In fact, capital punishment. Particularly in India, Pakistan, and what have you, it's capital punishment. But here we can reduce it to life imprisonment.
Yeah, DSP, the motion was on 20 years, but the counter motion is on life imprisonment.
Mr. President, we don't have that in our rules. Once there's a motion, somebody seconds, then it will be put to vote. If he fails, then he can raise his own motion. We don't have this. It's alien to our rules.
Okay, but we bear in mind.
It's alien.
We bear in mind that he has a counter motion.
You can do that. But he knows, it's an experienced legislator. He knows at this point, you cannot change this. You should put a vote, defeat it, then you bring forward his own motion.
Okay, those in support that defilement of minors should carry 20 years imprisonment in the act, say aye. Those against say nay. Okay, so that is defeated. Yes, you can now move. Your mic.
Thank you, Mr. President, sitting in the chair. My distinguished colleagues, I want to propose that the punishment for defilement is, for minor, is life imprisonment.
So in this case, it doesn't matter whether it is a woman or a man that does the defilement. The most important thing is that if a woman lures a minor to defile, life imprisonment. If a man lures a minor to defile, life imprisonment. Any seconder, Olamileko, because you feel very strongly about this. You are going to make sure that nothing like that happens to Ogun State.
Thank you, Mr. President, sitting as chair, Adeola Solomon Olamileko. I rise to second the motion as ably moved.
Dr. Akiyode-Afolabi, language is very important, and language does matter, because from what we heard from the Senate President, he says the defilement would apply to both gender, but in the wordings, in the draft, it says the girl child, it was left out. And this questions the motivation, and if they really did, the boy child was left out rather. It questions the motivation behind this bill, and if they did a thorough job and research and wide extensive consultations before they came out with this. Having said that, is there still room for amendments, for civil society input to be taken and feedback so that they can correct the anomalies in this bill?
Well, what they did was also to subject the bill to a committee of judiciary and human rights to take a more further look on the bill. Although from the information from the National Assembly, it appears that the only aspect of the bill that's been stepped down for further consideration is the section 230 that has to do with the penalty for supplying abortion, including drugs or instruments, which is the only area that they had disagreements upon that they felt was fundamental to be stepped down, for further conversation. But we don't think that the issue is closed. It's an issue that we need to, engage them as civil society to ensure that they do what is right. Apparently, with the conversation at the National Assembly on that day, it's obvious that the bill was not properly discussed. And probably also, if you look at the few numbers of people that are at the National Assembly, so the expertise that is required, to be able to have a bill that can really be sufficient, for the society was actually lacking. And that's why, from what we're seeing in the bill is talking about defilement of women and girls. And the question about defilement, especially when it has to do with unlawful carnal knowledge, can only happen to a girl under the age of 18. And so if it's above the age, it becomes rape. So there is a lot of contradiction in terms of language, that is used, on the floor of the house with respect to defilement. So while they were trying to make it a more gender-focused section, but you can also see that from there, except because that was also a discussion, so it's possible that they will still go back and do a final rewrite before, they present it. But as it is, it doesn't speak in that regard. But I want to quickly go on the one that is contentious, which is the Section 230, which deals with increased penalty for supplying abortion, inducing drugs or instruments. I believe that one really deserves, special scrutiny. As we speak, if you look at Section 228, 229, 230 of the Criminal Code Act, Nigeria already has a highly restrictive abortion law. And this amendment, what it will do is going to further criminalize what is often seen as healthcare, for women who have to, access, safe termination of pregnancy or abortion facilities. And we need to know, because data is very important, 35 million women undergo unsafe abortion. In this year alone, statistics is very clear, and it has resulted to about 22,000 or more, deaths. 97 of such is in places like Nigeria, where there are issues of social, political, and other conditions that affect, the full operation of our healthcare system. So there are political issues, there are social issues, relating, to this. So having a restrictive abortion law or criminalizing abortion has not helped us over the years. People have no information. The state is not responding to issues. There are issues of incest, there are issues of rape, and this law is not dealing with it. So the law needs to come in contact with the current, context. Conversation around abortion is not a moral issue. It is a public health issue. A lot of young teenagers are dying as a result of unsafe abortion. So I feel that, they're stepping down this conversation, allows for civil society to be able to engage with data, to let the parliament know that there is a problem, that is affecting and that is unsafe abortion is killing so many, young people, and particularly teenagers. And there's a need for government to be responsible enough to decriminalize, and make abortion much more open, for people in Nigeria to be able to have information, to be able to access, in a safe environment. Unsafe abortion has resulted a lot to the death of as many people as possible, and not only in Nigeria, all over the world. So Parliament should take that as an important aspect, it's not a moral issue, it's a public health issue, and it's known all over the world.
Okay, I mean, we can also speak to what the setbacks are in that regard. I hear you when you say it's not a moral issue. there's then the, the faith perspective, which might also be a pushback. But we'll expand this conversation further after this break.
Welcome back. Very important conversation is what we're having here on Breakfast Central. It concerns you watching us now because we're looking at the bill, the Criminal Code Amendment Bill 2025. And our two guests have been doing justice to the conversation, dissecting it and breaking it down for your benefit and also for the benefit of all who are Nigerians. But let's go back to the bill. My two guests are still here with us. Let's look at the aspect of a very critical aspect in terms of inclusivity. How would you say the bill can be more inclusive? Especially, my colleague did reel out where the boy child was not mentioned. Also, there are instances where you've mentioned the difference, miscarriage, and of course, abortion. And then what is needed? What do you think should be added now so that we can forcefully, whether we like it or not, through the bill, take away any form of pandemic that is bedeviling the existence of either the girl child, the boy child, or the existence of these criminal acts? I'm going to come back to you, Mrs. Dorothy. Can you share with us?
I'm just Dorothy.
Okay, that's
so to start with, the issues of defilement and rape, the extent to which they are different. Rape is rape. I'm a survivor of, child sexual abuse and adult sexual abuse, and I can speak authoritatively and say rape is rape. I take a cue from how Edo State handles it. It is rape of a minor or rape of an adult, and for what it's worth, trying to make one look like it is more severe than the other is pretty unfair, because we are different individuals and we react differently to different, forms of trauma. And so I think that if we recognize that, rape is penetration without consent or sexual inappropriateness without consent, across board, it should be seen as the same thing. Maybe defining minor or not minor would help us put things into better context. But I strongly contest, the language of defilement and all those kind of things. With issues around abductions, I saw things around the guardian of the child, the parents of the child needing to grant express consent. Otherwise, abduction is said to have been taking place, and it's for a girl who is 16 years of age. Children are people under 18 years old. So what happens to the 17-year-old girl? What also happens to the boys? These are critical areas of concern for me with the documents that I have seen. One would have thought that the amount of engagement we have been doing with the legislators on different things, including the Gender and Equal Opportunities Bill, amongst other things, would have helped the drafters of this to be more sensitive to the language, to be to have more gender balanced perspectives or gender neutral stances on the crime, so that the focus is on the crime and the beneficiaries of whatever they're coming up with, would not be discriminated against on grounds of gender, whether they are male or they are female. But I see that as a critical gap that is missing. Again, like I said, with the adoption issue, for instance, in cases where the violators are the parents, and the law is still requesting for express permission to be granted by parents, it means that it's the will of the parent and not in the best interest of the child that the law, that is being recommended is supposed to serve. And that runs contrary to the provisions of the Child's Rights Act. That runs contrary to the ideologies of the Child's Rights Act, in which everything is supposed to be in the best interest of the child. And it's important to remind us that whether we like it or not, critical issues have arisen again. The Child's Rights Act recognizes people who are under 18 years old as children. Nigeria is a secular state. Even religious states, Saudi Arabia and co, have pegged the age of children. What is Nigeria shying away from? I think that the earlier we start saying medical crisis, public health crisis as public health crisis, and stop excusing them on, with ideas of religion or culture or whatever it is, the better for us. Do we have progressive leaders of faith and culture who have been clear on, or misinterpretations of ideologies or where religion stands? Yes. To what extent are the legislators aligning themselves with progressive stances in line with the current day realities? There's a huge gap that is noticed there, in the language of what is proposed to be an amendment or an improvement of the existing criminal code. And
Dorothy, I think
at best,
I think you've raised a very critical, very, very critical conversation just now. And your question, are we shying away from pegging what a child's age really is? If we're putting it at 18, and then other parts of the world, they do have that. Maybe because of our, in quotes, maybe there's some religious connotations and so on that may one way or the other affect. And whether we like it or not, this point you raised now, it's also going to affect this same criminal code that we're looking at in the future, one way or the other. Dr. Abiola, I don't know if you have a look, if you have a different view on this as well. Would you like to share?
Well, I think we can't have two different laws in country. The age of a child is children up to the age of 18. So the law can't be talking about 16-year-old living 17, and 18 years old. Now, one of the things that I think, just to also further buttress the point that my colleague Dorothy made, the bill seems to be retaining very paternalistic and archaic language. So the question of inclusion is very important. While we have talked about the need to include the boy child, the language itself must be inclusive. Trying to increase the number of years for sentencing is not the only way, to address issues that has to do with defilement. Having a bill that is speaking at this time, like speaking in the Victorian era, is not acceptable. It's talking about female sexuality and autonomy. If you look at all the sections that, the bill is dealing with, it's dealing with more about women. And it's talking about women and girls in a way that is saying as if they lack agency and that they are like perpetual objects, using the word like detained, and parental consent, and a whole lot of other things. All these issues have been issues that have affected, the rights and autonomy of either the girl child or the woman at a point in time. For example, at a point in time, the question of consent for child marriage, was discussed. So bringing those issues of parental consent and all that issue back, to a large extent, it's returning the discussion to seeing girls, women as properties, that are being owned, that decisions can be made, on their behalf. And we know that some of those decisions are based on cultural or religious context. So, if a deeper look at the law, does not really provide the kind of, best practice that you would expect, that the law will be able to respond to. And if you look at the other section, there's a particular section talking about possession of human head, talking about juju and all of that. You'll find it very difficult, to see if we're discussing the law at this level, talking about brothels, talking about so many things, the wordings of that law that are not, in compliance with what, the situation is. So it looks to me like the legislatures are not in touch with, the current reality, in the society. So generally, it's important to, look at every bit of what is being suggested. The emphasis on 5 to 10 years, 2 to 3 years or whatever, that is not the emphasis. We need to have a law that is victim-centered. So the approach of making the law particularly that has to do with dignity of people, that has to do with the bodily autonomy and integrity of people, it must be centered around, the people. And I realize also that on that day, I think the only woman who was in the parliament who wanted to raise issues around the issue of abortion stood up, and she was not even allowed, to make that comment. So it's really a whole it's an issue of concern about who is also making the law, what is the understanding, of the people making the law. Because if you don't sit where women are sitting currently in the country, it might be very difficult for you to be able to understand, the challenge that women face. So these laws are not, inclusive. We need to reopen it. We need to have a more nuanced discussion. And people are asking, was there a public hearing? How did they pass through those processes without, getting the contribution of people, to be able to make the law nuanced and much more related to the realities of today?
Thank you so much. I'd like to bring Dorothy back into the conversation. Now, Nigeria's criminal justice framework often prioritizes punishment over prevention. If you could rewrite this amendment with 3 priorities, what would you include? What priorities would you include to make it truly protective and survivor-centered?
Okay, the first one is recognizing that children are emotional beings with human rights, and to that extent, not disregarding any group of children, including especially the 17-year-olds, the 16-year-olds, the 15-year-olds. They are still children. They cannot vote and they cannot be voted for. The well-being and welfare of children. Now, so a lot of daily I see children who whose parents are their abusers. I see children whose parents are the primary enablers of their abusers, amongst other things. And when people come up with these religious and traditional context to things, I'm also aware that the holy books make consent mandatory. And so in what way is a child who legally cannot consent to sexual activity able to consent to marriage, which would include sexual activity? I think these are critical areas that the law needs to be clear on its stand, because the quality of the law today depends on how much faith the children of today will have in the Nigeria they are going into. And then finally, victim-centeredness is something that we cannot overemphasize. Who cares for the medical bills? In sexual and gender-based violence recognized by the Health Act as an emergency, and the general hospitals of primary healthcare centers treat sexual and gender-based violence, looking for the to remove vagaries. So when you say unlawful, what does unlawful amount to? I think these things should be explicitly defined. What it sounds to me in this moment, it's like, Boys Club came together to determine again the best way to perceive and monitor the bodies of women and children. That's what it sounds to me. And I know that if we got a girls' club together to determine, for instance, that vasectomy is something that should be considered for all men, especially considering the rise of sexual and gender-based violence and empirical statistics, the issue of autonomy will come in, the issue of agency will come in. And so it speaks again to, you cannot plait my hair or shave my hair in my absence. To what extent are those of us who have these lived realities being considered, or are lived realities or inputs from us being considered? As a survivor of sexual and gender-based violence, I recognize that a lot of people who are interfacing with this thing are giving us these tokenist gestures because they think they know what is good for us. They are not speaking to us about our lived realities and their perceptions to be able to create a balance. So I would say that that balance is very, very much needed, because already, as a survivor of sexual and gender-based violence, I can authoritatively tell you that the wordings of these documents that we have cited so far are very triggering, very traumatizing, and nothing short of enabling the femicide statistics to rise.
Well said, Dorothy Njemanze, and also the conversation is one that I believe will keep going. Hopefully, like we always say here, when those at the top listen to the voices, they will be able to act immediately, especially for the benefit of what we've discussed so far. I want to say thank you so much, Dr. Abiola Akiyode-Afolabi, for joining us as well as Dorothy Njemanze for speaking with us on this issue. We look forward to have you ladies once again so that we can look at how far we've come and how far we're going, especially on issues bordering on such matters. Thank you so much.
And hopefully the authorities will take the feedback and improve on the draft when they go into the committee stage. Thank you so much for your time once again.
Thank you.